Good evening. This is John Milburn, Environmental Law, 30 April 2014. Tonight I'll be reviewing Bates' Environmental Law in Australia, Chapters 7 and 11. Chapter 7 dealing with ecologically sustainable development and Chapter 11 dealing with protected areas. Commencing firstly with Chapter 7, I'll refer you to page 220, and I note that the chapter runs through until page 258. As usual, I'll refer you to particular paragraphs which I believe are of importance. I'll start with paragraph 7.4, which deals with the Brundtland Report. Sustainable development was defined in that report as a development that meets the needs of the present generation while not compromising the ability of future generations to also meet their needs. The report came into being as a result of the definition of sustainable development in the World Commission on Environment and Development, the WCED. Now, that particular commission was asked to bring forward proposals for long-term environmental strategies, and in doing that gave an opportunity for the international community to cooperate and take action in relation to that objective. I'll continue at paragraph 7.5. Now, this is on page 221. And good evening, Laurie. At the heart of the problems of the environmental degradation, there are two major causes. Firstly, of course, a dramatically increasing world population. And secondly, powerful technological advances that enable over-exploitation of world resources. At 7.6, although the report clearly indicated sustainability is a vehicle for integrating economic development and ecological integrity, the sentiments inherent in it, while being largely accepted by governments worldwide, have not been immune from criticism. Over the page at 7.8, as a consensus document, it is bound to have weaknesses, says Bates. However, the fact that governments have accepted it and the principles of sustainability now appear in many international agreements, it does pave the way for the eventual incorporation of many of the principles into customary international law. And you'll recall that we spoke about customary international law early on in the piece when we were discussing Chapter 4 of Bates. Now, this is important in Australian law because the emerging norm of customary international law has been, since decided by the High Court, undertaken as part of our law, in that any clear legislative direction to the contrary accepted, domestic law will be interpreted and applied in conformity with customary international laws. I'll move forward to 7.15. Australia has fully embraced the concept of sustainable development through both policy initiatives and legislative reforms. ESD is a concept. Statutory requirements to have regard to ecologically sustainable development when making decisions appears not just in environmental legislation, but importantly, in legislation conferring discretionary powers on a wide range of government agencies to take or approve activities that might impact adversely on environment and natural resources. So we see there in that statement how the legislation can provide directions to the administration or the administrators performing executive function. Although legal definitions of the concept differ, most fundamentally are based on the agreed statements embodied in the National Strategy on Ecologically Sustainable Development from 1992. Now, in that definition, if I could highlight, the strategy came to the following conclusion: that ecologically sustainable development requires the effective integration of economic and environmental considerations in decision making. Now, that's consistent with what was considered in the Brundtland Report in '83, and goes on to say that it can be achieved through implementation of four things. Firstly, the precautionary principle. How often are we hearing that now? Second, intergenerational equity, and there's some commentary in relation to that in the chapter. Conservation of biological diversity and ecological integrity is the fourth thing. As well as that, improve valuation, pricing and incentive mechanisms. So they're all ways in which governments can support ecologically sustainable development through legislation and administrative practice. Over on page 228, 7.20, the Sustainable Planning Act in Queensland refers to ecological sustainability as the balance that integrates three things: protection of processes, economic development, and maintenance of well-being of people and communities. Over the page, the definition clearly emphasises the need for decision-making that adopts the broadest possible worldview. Now, how does one possibly establish that there is a worldview in the consideration? Well, perhaps I could only say that expert evidence is critical in those matters, as is often the case in any dispute involving environmental law. At 7.22, legal definitions of ESD are problematic, and few requirements in legislation are contained which actually require maintenance or monitoring of the sustainability of the outcomes. At 7.23, a common drafting technique in legislation is to specify ESD as one of the objectives of the legislation to which decision makers should have regard. Now, we talked about that in earlier chapters, where we made comment to the effect that it is possible for the decision maker to give it no regard. It is simply a matter which must be considered, but having regard to it can theoretically mean having zero regard. I know that sounds a bit inconsistent, but the idea is to consider it, but even if it's discounted as being irrelevant, it has nevertheless still been considered. At 7.25, Minister for Planning and Walker, 2008, the Court of Appeal, this is New South Wales, said it was considered mandatory to consider principles of ESD, then consideration would require that the substance of those matters referred to in the principles and programs be addressed. The conclusion in Walker, this is at 7.26, reveals an important principle, that requirements to consider principles of ESD may be given more explicit and practical meaning in planning instruments, requirements for assessment, environmental assessment of projects and activities, and that brings into comment and play those comments made by Phil Jeston yesterday. Over the page, the hub of an application for construction and operation of a waste disposal and recycle was, in that case, rejected on appeal. Now, down the bottom of that paragraph, in that instance, the waste disposal facility was rejected. It was on prime agricultural land, and the ability for future generations to enjoy that land and the qualities available to it in the future was a major issue of concern, and it did raise the principle of intergenerational equity, which, as we've identified, is one of the four principles associated with ecologically sustainable development. That, however, does, to my mind, raise issues with respect to compensation for the landowner of that particular property, and we've discussed compensation at length in the past. This is at 7.28. The attainment of intergenerational equity was also a central feature in Taralga Landscape Guardians. There was an application for development consent for wind turbines, and in that case, reading from the quotation at the bottom of 232, the attainment of intergenerational equity in the production of energy involves two requirements, said Justice Preston. The first is that the mining and the use must be sustainable, but the second is, as far as possible, to increasingly substitute energy sources which result in less greenhouse emissions is to be pursued. So the overall public benefits of development could therefore be said to outweigh any private disbenefits in that particular case. At 7.30 at the bottom of 233, in Lawyers for the Forest against Minister for Environment, it was argued that risks to marine environment from effluent should be met by an application of the precautionary principle. Now, the precautionary principle is a concept. It's aligned to the principle of ecologically sustainable development. At 7.31, if ESD is to be pursued seriously, then surely this would be the paramount objective of legislation. It should be the outcome that decision makers strive to achieve, not part of a process that simply requires ecologically sustainable development to be considered. And I've stressed that paragraph because I think that sentence, or those two sentences rather, are a key issue in terms of the arguments being promoted by Bates. So that's the first two sentences of 7.31. Over the page, also very important, at 7.32, it is difficult to resist the criticism of current drafting approaches that by including ESD as one of the number of objectives in legislation, or as one of the number of features to which regard should be had by decision makers, it missed the point that ESD is not a factor to be balanced against other considerations. Quite strongly, Bates says, ESD is the balance between, or rather integration of, development and environmental imperatives. Argument supporting that suggestion goes right back to the report, the Brundtland report, where it came to the initial conclusion of what ecologically sustainable development is all about. At 7.34, midway through the paragraph, there are bound to be trade-offs between the often competing components of ESD. ESD attempts to maximise the total combined effect of economics, social and environmental values of resource use, but to do so, the sum of the elements that makes up these values may have to be traded one against the other. And that's what Bates is really saying, that this is not necessarily a factor to be considered. It is the balance between these competing interests of economic and environmental factors. There's some commentary in relation to public interest as a trigger for considerations of principles of ecologically sustainable development. That follows on from the comments made by Phil Jeston yesterday in relation to the EPBCA. At 7.40, perhaps we can take you straight to the summary. I just want to stress the first two of the 4 points that are raised. A statement in legislation that a decision maker must consider the public interest does not necessarily include an obligation to consider ecologically sustainable development. However, this is two, in most cases, given that the all-embracing nature of sustainable development, public interest is likely to include ESD as a mandatory relevant consideration. Over the page, the precautionary principle. This is relevant to the assignment in Laws 11046 and also relevant to the examination in that subject. The 7.41, the precautionary principle in Australia, as it's conceived, for example, Sustainable Planning Act Section 5, states that where there are 1, threats of serious or irreversible environmental damage, then 2, lack of full scientific certainty should not be regarded as a reason for postponing measures to prevent environmental degradation. So they're the two factors. We must have the threat of serious or irreversible environmental damage, and 2, the lack of full scientific certainty. If we don't have both those, then the precautionary principle simply doesn't apply. So the principle is therefore triggered by the satisfaction of both those conditions precedent. In law, lawyers talk about conditions precedent or conditions subsequent. If it's a condition, it means it's something which is attached to the principle. If it's condition precedent, it means these things have to be in existence first before you go further. So unless these conditions precedent are present, the precautionary principle need not be applied. It is essentially a risk management paradigm, is a way of describing the precautionary principle. In the application, says Bates, of the precautionary principle. Yes, Laurie?
Sorry. I was just wondering, so when we do the assignments, we look for the precautionary principle first before we proceed on, or?
Sorry, before you proceed on?
Yeah, do we look for if there's a precautionary principle?
Oh, look, I think the precautionary principle has to be considered in all instances of environmental law. I think it's, you remember we talked about the precautionary principle early on in the piece when we were talking about international obligations and how it's gaining in importance collectively through environmental law. I think it would be rare for a situation where the precautionary principle isn't at least considered. I'm not necessarily saying that you have to look for it first, but I think it needs to be addressed in almost anything to do with environmental law. So I hope that answers your question, Laurie.
Yeah, so if there's a threat to the environment, then we have to consider it. Is that right? If there's a threat to the environment,
yes,
or the project may have a threat, or have a threat to the environment, or like an endangered species or anything like that, then
yeah. But bear in mind, of course, it has to be a serious threat or a situation where there'll be irreversible environmental damage. But also, it has to be coupled with a situation where the science is not yet concluded. If the science is concluded, then the precautionary principle doesn't apply. So there needs to be an assessment as to the quality and state of advancement, if I can use that term, of the science behind the threat, which might be serious or irreversible.
Thank you.
Thanks, Laurie. So Bates says at 7.41, in the application of the principle, public and private decisions should be guided by careful evaluation to avoid serious or irreversible damage and an assessment of the risk-weighted consequences of various options. And you recall Phil Jeston made comment that as advisors, they will sensibly err on the side of caution, both in terms of potential referrals and the way in which the environmental impact assessment is prepared in relation to new projects. So the principle has been described as vague or fuzzy because it doesn't define precaution. It doesn't indicate how precaution should be taken. It's therefore notoriously difficult to apply as a legal standard than an approach into decision-making on the merits. So what we mean by decision-making on the merits is, generally speaking, an administrative or executive decision where all things taken into account. This is the decision that's made. So when we talk about a merits appeal, we're really talking about that process being renewed afresh, de novo, by the court. So it's really something that needs to be considered in all decision-making aspects on the merits, in my view. It may be discounted, but I think it needs to be at least considered. Getting back to what you were saying, Laurie. At 7.42, the trigger for application of the precautionary principle is a threat of serious or irreversible environmental damage. Over the page, and this is the point I was making before, inevitably science will be called upon to supply evidence to support the application of the precautionary principle. It seems to me that there's going to be an awful lot of work in the future for environmental scientists. How much scientific uncertainty needs to be there to constitute a threat of environmental damage before the second condition precedent is triggered? At civil law, an action will be successful if it can be proved on the balance of probabilities. However, and we talked about this in week 1, the generally accepted scientific criterion for probability is 95%. So we have two different tests there. And of course, for criminal law proceedings, the test is beyond all reasonable doubt. So that's a third test. I'll take you through to 7.53. Bates says, in using the precautionary principle, the response should be proportionate to the risk, and that the precautionary principle, where triggered, does not necessarily prohibit the carrying out of a development plan, program, or project until full scientific certainty is attained. So there is the risk, and Bates really makes that point there, that we might be in danger of collectively going too far the other way, and as soon as there is some risk assessed and there's some uncertainty from science, there may be a propensity to discontinue projects, but there's no reason at law why that has to happen. The precautionary principle is often raised in cases, says Bates, in which it is probably not appropriate to do so. So the concept of caution rather than precaution is probably more apposite for those cases. So bear that in mind. If you're discussing the precautionary principle, you've really got to distinguish precaution with caution, if you understand what I mean. The burden of proof. Generally, it falls on the applicant. If a proponent of a development has received approval, anyone challenging that right must prove why the licence should be refused. The introduction of the precautionary principle suggests a fundamental shift in the burden of proof associated with granting a consent. As a legal test, 7.55, and this is an important paragraph, application of the precautionary principle would require an objector to a proposal to bring forward legitimate scientific evidence that raised the possibility of serious or irreversible environmental harm. The proponent would then be required to disprove that possibility beyond reasonable doubt. This approach means that application of the precautionary principle effectively reverses the normal burden of proof from the objector to the proponent of an activity. So in law, we sometimes talk about a prima facie case, which means on the face of it, it's there. If the objector can bring forward some evidence to show the possibility of that harm and the science is still out, then really it falls back to the proponent of the proposal or the protagonist for the proposal to disprove that scientific evidence. At 7.56, Bates refers to Telstra against Hornsby Shire Council. In that instance, Chief Justice Preston, as he was then, said the rationale for requiring the shift of burden of proof is to ensure preventative anticipation to act before scientific certainty of cause and effect is established. At 7.57, Bates makes reference to criminal lawyers who, accustomed to seeing cases decided on on proof of innocence or guilt, which depend on the evidence satisfying a theoretical standard, the reversal of proof would be significant. In criminal law cases, there are some examples. For example, in drug-related matters, if illicit drugs are found on a particular residence or in a particular residence, and you are an occupier of that residence, then even though you may not have been specifically aware of the existence of the drugs in that residence, you can nevertheless be charged and be found guilty. In essence, there's a reverse onus where you need to establish that you did not know or reasonably suspect that the drugs were there. The same thing applies to a charge relating to possession of tainted property. In some instances, the onus is reversed and you need to prove that you didn't know that the items in question were tainted. Anyway, back to environmental law. In 7.58, coming back to that case of Telstra and Hornsby, could I commend what is said by Chief Justice Preston as a very good judicial summary of the precautionary principle. And I'll quote selectively from what he says, but read A to I in depth. So the application, this is A, the application of the precautionary principle is triggered by the satisfaction of two things. One, threat of serious or irreversible environmental damage, and two, lack of scientific certainty. That's well established now. Once both these conditions are satisfied, precautionary measures should be taken to avert the anticipated threat, but they must be proportionate. B, it's not necessary that serious or irreversible damage has actually occurred. If there's no threat, or if there's no scientific uncertainty, the precautionary principle will not apply. C, if the two conditions precedent or thresholds are satisfied, the precautionary principle will be activated, and it's at that point that there's a shift in the evidentiary burden of proof to the proponent of the scheme or development. D, the precautionary principle permits the taking of preventative measures without having to wait. E, the principle should not be used to try to avoid all risks. Zero risk precautionary standard is inappropriate. Precaution versus caution. F, the type and level of precautionary measures that will be appropriate will depend on the combined effect of the degree of seriousness and irreversibility of the threat and the degree of uncertainty. In other words, even though there may be some scientific uncertainty, it is appropriate to consider the degree of the uncertainty. As scientists studying this course, you might be concerned about the lack of quantitative statements to support these matters. You know, for example, are we talking 99%? We're talking 95%? We're talking 90%? In law, I'm afraid, rarely do we have that certainty, and many arguments are had as to what exactly is meant. Anyway, coming back to what was said by Chief Justice Preston, G, the precautionary principle embraces a concept of proportionality. H, the principle, when triggered, does not necessarily prohibit the carrying out of a development until full scientific certainty is attained, and the precautionary principle is but one of the set of principles of ecologically sustainable development. So that's a really good summary. 7.59, Bates refers to Dixon and Australian Fisheries Management. The tribunal in that case suggested that the authority could use the precautionary approach even if the threshold had not been met. So it may be that the principle can in some instances be considered administratively, that is cautiously even, rather than necessarily formally being adopted. Now, we've talked about intergenerational equity as being one of the ways in which the ecologically sustainable development argument can be considered. So I'd refer you to 7.62, and I'll just simply say that the principle is inextricably linked with sustainable development. Over the page, conservation of biological diversity and ecological integrity. This is the third issue. In the definition, conservation is expressed to be of fundamental consideration, and I've underlined that in my notes, in decision making. The EPBCA is relevant in that regard. Over the page, the definition of ecologically sustainable development does not make biodiversity conservation a necessary component. Where a number of factors are mandated for consideration without any statutory indication as to priority or weight, then the relevance of those factors is a question of fact for the decision maker to determine. And we talked about that before. Therefore, if protection of biodiversity is at most accorded a weighting, only equal to other factors, then due weight to be accorded to biodiversity protection after consideration by the decision maker may legitimately be determined to be nil, says Bates, which confirms an earlier statement that I made. Decision makers are able to lawfully make decisions that impact significantly and adversely on biodiversity. Use of the precautionary principle to address potential impacts on biodiversity is welcome. However, the list of threatened species is likely to continue to grow. Improved valuation, pricing and incentive mechanisms. 7.68, the principle means that environmental factors should be included in the valuation of assets and services. One example, polluter pays. Another, the user of goods and services should pay prices based on the full life cycle costs in providing those goods and services. Over the page, this principle is based on the policy that if the real value of natural resources is reflected in the cost of using those resources, then resources will sustainably be used and not wasted. This, of course, begs the question whether we can value environmental assets, and if so, how do we do that? So the conclusion to the chapter on page 258, clearly the principles of ESD are intended to influence governments and therefore corporate and individual decision making. However, as principles, they tell us little about how to translate those concepts into practical action. As familiarity with the principles grows, courts and tribunals play an important role by setting benchmarks for future decision making. And of course, we're at that stage where it's also new, environmental law. That's all I propose to say at this stage about ecological sustainable development and the precautionary principle. If there's no questions, then I'll move on to chapter 11, dealing with protected areas.
I'm sorry, John, but I have to go. Sorry.
All right, Laurie, all the best. We'll see you next time. Thank you for joining us. Chapter 11, protected areas. This is dealing with pages 435 through 470 in Bates. And my overall analysis will be fairly brief. You would have noticed that there's the Commonwealth regime from page 438 through to 453, and the state regime effectively through to the balance. Queensland is on pages 456 and 457. So let's have a look firstly at the Commonwealth regime, which of course is governed by the EPBCA, which deals with the declaration and management of various types of protected areas managed by the Commonwealth. At 11.9, the development of a comprehensive, adequate and representative national reserve system rests on bioregional framework, which is an area comprising of a whole ecosystem and several interconnected systems, where they may be governed, or where they may be geographically separate to each other. The IBRA, which is referred to at the bottom of that paragraph, divides Australia into 85 bioregions. 11.14, it's an offence to take action that results in a significant impact on the World Heritage values of a declared World Heritage property. There's reference to Booth and Boswick, 2001, where the court concluded that flying foxes contributed to World Heritage values of the area and that continued use of devices for killing them was likely to lead to significant impact. However, by contrast, an application for an injunction to restrain the culling of dingoes on Fraser Island because of aggressive behaviour towards visitors was rejected in the federal court. Now there's reference to the Great Barrier Reef at 11.17 and 11.18. It's an offence to enter zones other than permitted in White and Patterson, commercial fishermen who neither had a proper functioning instrument nor the skills to use them, was nevertheless convicted under the provision because the fisherman's degree of negligence was of such high risk that it fell within the standards set by the Commonwealth Criminal Code to constitute negligence and merited punishment for the offence. We'll talk more about offences later, but there is that distinction between a willful act, an intentional act, and something which is the unintended consequence of a willful act. In this instance, the fisherman was fishing. That was a willful act. The consequent damage done as a result of drifting, presumably, was not intended, but nevertheless was regarded as criminally negligent, and therefore the fisherman was liable to be punished. Recognition of the dangers to the reef from oil spills have resulted in a scheme of compulsory pilotage on regulated vessels through the region. Phil Jeston yesterday made reference to Ramsar wetlands. that's described in 1.1.21 as an area designated by the Commonwealth under the Ramsar Convention. At 11.27, management of reserves, a management plan must be prepared for reserved areas. At 11.29, certain activities may only be carried out in accordance with the plan. There's reference there to the case of the Minister against Wilson, where the respondent set a net, caught a shark, knew he was close to the border of the park, didn't know his vessel had gone in, but nevertheless was ordered to pay a penalty of $12,500. Similar, of course, to the fisherman case earlier. Conservation agreements may be made, this is 11.38, with any person for the purpose of enhancing the conservation of biodiversity outside Commonwealth reserves. And those agreements are binding not only on the person who entered into the agreement, but also on any successors to interest of such a person. Now, Phil referred us to a website where searches can be undertaken in relation to many of these factors, and the link is on the Moodle site. I would commend that you go to that link, type in an address, your own if you like, as I mentioned on Moodle, and just have a look around and see what can be done. It's also an important factor for conveyancers to be aware that these matters do carry forward and bind the owner of the property at any particular stage. Now, let's move on to state and territories. At 11.42, the objects of reservation are to protect flora and fauna, natural features, provision of recreational facilities, and education, scientific and research purposes. The Queensland position, which is governed by the Nature Conservation Act, is outlined at 11.47, where the Act declares the objects of nature conservation are to be achieved by integration and comprehensive strategies, which involve protection of areas of diversity, natural features, and wildlife. There is then some commentary in relation to marine aquatic reserves. 11.56, although the Commonwealth has constitutional sovereignty over coastal waters, the terms of the constitutional settlement between the Commonwealth and the states effectively mean that Commonwealth reserves will be declared from 3 to 200 nautical miles from the coastlines, while the states may declare marine reserves within that first 3-mile radius. Isn't it odd that we talk about in terms of miles when we're talking about nautical law? At 11.66, there's commentary in relation to development in reserved areas where it's restricted but not totally prohibited, and reserves are often managed for multiple uses, which means that management plans may allow for mining, forestry, and other operations. At 11.67, one problem that multiple use brings, of course, is the possibility that 2 or more government authorities may be responsible for management of the area, for example, national parks and a mining or forestry department. Where there is a clash of management interests, the provisions of a specific plan, for example, for forest management, will prevail. And that's a general rule of law, that where there's a conflict between the general and the specific will override. Look, the final comment that I'll make for this evening, it's at 11.73, is that under the heading of offences and enforcement, Bates has referred us to the decision of Carter and Wall. Just a reminder, when we're talking about a case, we don't say versus. It's either Carter and Wall or Carter v. Wall, perhaps, or Carter against Wall. I tend to go Carter and. So Carter and Wall, 2002, the defendant removed 3,000 mango trees from a protected area in contravention of the legislation, where the court imposed a fine of $10,000 and ordered the defendant fence the area to enable natural regeneration protection and maintain that fencing for 5 years. All right, so that brings my commentary for this evening to an end. And next week, next Tuesday, that is the 6th of May, we'll be dealing with Chapter 13 of Bates, which deals with native wildlife and threatened species. That'll be a relatively quick session. All right, now there's no questions on the chat line. If there's no questions, I thank you for your attendance, and I'll end the meeting now, and all the best with your studies.